Continuing Chapter 3. Military Force. Cost plus contracting and the perceived need to fulfill every military planner's dreams mean that military spending in the United States is enormous and represents a vast direct subsidy to a variety of defense contractors. But spending on military activities also offers indirect subsidies to multiple industries. The use of tax-supported military force in Central America to make life easier for U.S.-based banana growers is an obvious instance of state subsidy to a particular industry that benefits elites while imposing significant costs on local workers and their communities. Using military personnel to open up access to oil for elite-owned firms is clearly another. The state helps to create and preserve hierarchies. State monopolies and subsidies encroach on people's creativity and autonomy, encourage inefficient allocations of resources, and force ordinary people to pay tribute to politically connected elites. In addition, they encourage the creation and maintenance of organizational structures that disempower workers and disrupt communities. Hierarchies are inefficient. Large hierarchical organizations are inefficient. Increases in size can certainly offer some economies of scale, but there are also diseconomies of scale. Managing information, monitoring workers, transporting goods over long distances, all necessary to the effective function of such organizations, are costly. They are so costly that, without state support, it's likely that many big authoritarian organizational bureaucracies would prove too inefficient to survive. This is true in part for the same basic reason the state can't manage production and distribution. Whether you're talking about an enormous, centralized authoritarian organization trying to make decisions for an entire economy, or about a smaller but still centralized and authoritarian organization trying to make decisions for a correspondingly smaller segment of the economy, some of the basic issues are the same. Information, vital information, is distributed throughout an organization. No one person or unit has access to all of it. And the larger the organization, the more difficult it is to assimilate all of this information, and the less information any one person is likely to have. Also, within a large business, there will often be no meaningful way to determine prices for the goods and services different units provide each other, since the different units don't actually own these goods and services and will have limited capacity to price them reasonably. The presence of distributed information and difficulties with internal pricing both limit the efficiency of large firms. But these firms don't have to confront the actual costs of being large, because the state subsidizes them, some more than others of course, with a vengeance. The corporate form is partially a subsidy. Start with the corporate form itself. To some extent, at least, it's something that wouldn't exist without state action, which offers multiple benefits to the people who are able to take advantage of it, notably limited liability. Limited liability protects the people who own a corporation against lawsuits. It means, in general, that a successful lawsuit against a corporation can touch only the corporation's assets, not the assets of the investors who are often legally and socially identified as the corporation's owners. In contemporary law, limited liability comes in two basic forms: limited liability in contract and limited liability in tort. Contract damages are awarded in light of agreements people made with each other, as, for instance, when someone fails to fulfill a commitment to deliver promised goods and causes a business loss as a result. By contrast, a person is liable in tort when she harms someone's interests, whatever his or her relationship with the liable person or entity. It's easy to see how a firm could arrange for limited liability in contract without any action by the state. When making an agreement with a person or another firm, it could simply ensure that the agreement included terms limiting liability in case the agreement was breached to the assets of the firm itself. It wouldn't need corporate status to do this. It could be a sole proprietorship or a partnership. However, the cost of ensuring limited liability protection might be greater than it is now, especially if the absence of the corporate form required a firm to negotiate for limited liability on a case-by-case basis. Whatever might be true about limited liability in contract, without the protection afforded by state-created corporate status, it's not at all obvious that a firm could enjoy limited liability protection where tort suits were concerned. Suppose a firm is responsible for a toxic chemical spill that results in a cancer epidemic that devastates a small town, none of whose residents had any special relationship with the firm. If the firm is a sole proprietorship, a lawsuit against it could reach the assets of the proprietor. If it's an ordinary partnership, a lawsuit could reach the assets of the partners. In each case, the legal owners would be liable for the firm's debts. But a lawsuit against an incorporated firm could reach only the assets of the firm itself. Without the limited liability protection that comes with incorporation, shareholders, who are currently treated as the legal owners of a corporation, might themselves be liable for debts resulting from torts committed by the corporation. Whether they would depend on just how much control went along with their supposed legal ownership, what kind of influence they exerted on the people directly responsible for the torts, and what kind of influence they could have exerted. Whatever might be true of the shareholders in particular cases, there's obviously a strong case for unlimited liability for directors, who are responsible for overseeing the activities of executives. But there surely would be times when at least some shareholders, especially institutional investors with significant influence over directors, would also be liable for corporate torts if state-provided limited liability didn't protect them. Exposure to this kind of liability could make people more cautious about investment decisions. They might be more likely to limit their support to projects they regarded as low liability risks. If they didn't, they would need to take action to protect themselves in case courts awarded significant tort damages against firms in which they had invested. Presumably, they would buy significantly more insurance than they do now. Many would probably also make various kinds of indemnification agreements. Irresponsible corporate decisions might be less likely to occur. By providing a corporation with limited liability protection, the state is subsidizing no-strings-attached risky behavior, what economists often call moral hazard. Simultaneously, it is effectively stealing from people who are unable, because of limited liability protection, to obtain remedies for harms they've suffered because of corporate misbehavior endorsed or promoted by investors. In addition, the state-granted privilege of incorporation turns the corporation into an entity that's supposedly distinct from shareholders and workers, managerial and otherwise. Investors receive dividends, sometimes, from the corporation whose shares they own, but their actual involvement in corporate governance is frequently limited in ways that certainly might sometimes justify limited liability. This is not just because limited liability can reduce or eliminate incentives for an investor to remain actively involved in the affairs of a corporation in which she invests. It's also because modern corporate law encourages the investor to see her role as limited. While the fiction that managers work for investors is repeated and, on occasion, emphasized, economic conditions and legal rules in fact give managers independence sufficient to enable them to act on behalf of the corporation rather than the shareholders. Sometimes this means acting on behalf of the corporation as a community comprising multiple constituencies. Rather more frequently, it means identifying the interests of the corporation with those of senior executives. If they choose, as they often do, these executives can simultaneously appeal to the independent existence of the corporation to justify their relative independence from shareholders, while pointing to their supposed responsibility to shareholders to justify disregarding the legitimate concerns of workers, local community members, and others. In this way, too, the state supports the existence of large corporate bureaucracies. Licensing requirements protect privileged businesses. Licensing requirements and many different kinds of regulations limit the kind of work people can do. Big businesses can cover compliance costs that similar startups often can't. Tax law arbitrarily rewards these businesses for doing things like reinvesting the money they make rather than distributing it to shareholders in the form of dividends, merging with other businesses, or focusing on expensive research leading to large projects that make or keep them large. Labor law enables businesses to co-opt unions while reducing pressures from radical labor tactics. By funding research and development activities, the state makes it possible for businesses that depend on those activities to grow. And patents, copyrights, and transportation subsidies all make it easier for large hierarchical organizations to function too. Patents and copyrights protect privileged businesses. Patents and copyrights concentrate wealth. Well-heeled businesses can afford to purchase patent rights and use them as bases for their own processes and products when others cannot. And the expectation of the payoff from successful patents and of protection from people who can't afford to prosecute patent applications and secure their patent claims in court creates incentives for the creation of wealthy organizations able to fund the long-term process leading to the acquisition of patents, something organizations with less staying power obviously find it harder to do. Patents have too frequently been used to keep people from delivering particular goods or services and to shut down otherwise fruitful and economically viable lines of research and development. And patent licensing and patent swaps have also helped businesses to create cartels with the potential to crush other firms and exploit the public.